Hi, my name is David P. Shapiro. I'm the owner and managing partner of the law office of David P. Shapiro, located in San Diego, California, where my firm helps good people regain control of their future when charged with a crime. This video, I want to talk to you about some defenses in San Diego to possession of child pornography. Child pornography are one of those offenses that when people hear it, they take a breath, they take a step back, and it upsets them, and understandably so. However, the burden of proof is exactly the same in a child pornography case as it is on a petty theft case, and it is on a district attorney prosecuting a DUI, district attorney prosecuting a vandalism. Burden of proof remains the same. And we need to hold the prosecution and law enforcement to that burden. But if you find yourself being accused of possession or distribution of child pornography, usually we're talking about Penal Code Section 311.1 and the subsections after 311.1 of the Penal Code involving child pornography, you need to make sure, just like you would with any other case, that you do not do law enforcement's job for them, that you do not do the district attorney's job for them. You keep your mouth closed. One mistake that we see a lot of times with child pornography cases are situations where police come to the house, they may have a warrant. It may be, particularly in San Diego, something known as ICAC, Internet Crimes Against Children. It's a task force. You may have someone from San Diego Police partnering up with someone from Chula Vista Police, partnering up with someone from the FBI, partnering someone up from the ATF, and it's this really unique group of law enforcement, and they'll come to the house with the search warrant, if they think you have possession of images or videos. And one of the first questions they'll ask is, whose computer is this? Why are you going to volunteer that it was yours? Why are you going to give them a key element that, I possessed it, that's mine? And not only that, a lot of times they'll say, okay, well, who else has access to it? Right? Because what they're trying to do is rule out a defense where you're going to blame somebody else. Hey, I didn't have access to that laptop. Other people had my password. It could have been planted on there. It could have been a setup. And far too often, before they hire an attorney, before they're aware of what their rights are, potential clients, future clients make statements that really hurts their defense. They accept responsibility. They accept ownership of the laptop. They accept the fact that no one else had access to that computer. And they close the door in many instances to a viable defense. That even if those images, as terrible and as alarming as they may be, are on that laptop, they still need to prove when it got on there and who put it on there and that you knew about it. Again, stressing the importance of keeping your mouth closed no matter what the offense is. Do not fall victim to strong-arm police tactics, to them being dishonest with you about it, them threatening that if you don't talk, they're it's gonna be worse for you. It's only worse for you if you talk and you admit things and you close door to defenses and you water down what a skilled, locally experienced criminal defense attorney can be able to do for you in your case to protect your freedom, to protect your future, to protect your reputation, to keep you out of prison. So if you find yourself in this situation where you're accused under investigation, cops come, start seizing computers, all that stuff, keep your mouth closed. The only time you should open your mouth after that is to reach out to a quality, locally experienced criminal defense attorney. We're just one phone call away, 619-295-3555.